Blake Lively, we are tired, boss. We are tired. We have looked at all the options, and the only conclusion is we are tired. What do you mean? You have 1,000 exhibits you would like to introduce a trial. 1,000 just for your side, and 40 plus witnesses? Babes, the trial is supposed to be 2 to 3 weeks, maybe a month. If God Himself.
Blake Lively's legal team just flooded the courtroom, and judges nodding. 1,000 exhibits, 40 witnesses, and a trial that may never start. Blake Lively's pretrial strategy is backfiring here, is what the court filings reveal. The legal move that exposed how worried Blake Lively's team really is. What 1,000 exhibits tells you about Blake Lively's courtroom position. Justin Baldoni's team asked for 1 week. Blake Lively's response said everything. Before this trial even begins, one side is already losing the argument. There is a version of this story where Blake Lively walks into a federal courtroom in New York with the wind at her back, a strong legal team, and a case that speaks for itself. That version is not what the court documents show right now. What the filings reveal instead is something far more telling than any headline has captured: a pretrial process that has spiraled well beyond the boundaries of what a case like this is supposed to require, and a set of tactical decisions by Lively's legal team that appear, at minimum, to have frustrated the court and, at most, to have signaled something deeper. That this side of the case is not as settled as the public has been led to believe. This is the story of what happened in the days leading up to a scheduled pretrial conference, what was filed, what was refused, and what the judge ultimately decided. It is also a story about strategy, about whether flooding a proceeding with documents is a sign of confidence or its opposite. Pay close attention because the details matter here, and the details are exactly what most coverage has glossed over. If you have been following this case and you want to understand it at a level beyond the social media take and the partisan headlines, stay with this. And if you find this kind of deep breakdown valuable, the best thing you can do is share it with someone else who is trying to make sense of this case, because the legal landscape here is complicated and it deserves more than a 30-second summary.
And her lawyers are trying to pull one of them, and then they quite literally turned around and try to tell the judge Justin Baldoni's team is trying to delay trial.
To understand what is happening right now, it helps to go back to the beginning of the conflict in this case, not the allegations themselves, which have been documented extensively, but the legal architecture of what Blake Lively filed and what Justin Baldoni's team has had to prepare for in response. Lively is the plaintiff in this civil case. She initiated the lawsuit. That means the burden of moving this case forward, framing the central claims, and marshaling the evidence that supports those claims rests primarily with her team. That is a fundamental point of civil litigation that gets lost in the public discourse, where both sides are often treated as equally positioned combatants. They are not. The plaintiff sets the terms of engagement at the pretrial stage, and whatever the plaintiff submits in terms of exhibits, witnesses, and proposed jury instructions defines the scope of what the defense must then prepare to count.
But here we got this order last night. The way for parties respectfully submit this letter to seek further 1 week extension. In the past, all the 1 week.
With that in mind, consider what Lively's legal team submitted in the days before the pretrial deadline. According to a letter filed by the defense, the team representing Justin Baldoni and his production company Wayfair Studios, Lively's counsel disclosed, just after midnight on a Friday, nearly 1,000 proposed trial exhibits. 1,000 for a single plaintiff in a civil lawsuit that is supposed to run no longer than 2 to 3 weeks at the outside. That number is not just large. It is, by any reasonable legal standard, extraordinary. To put it in context, cases involving that volume of exhibits are typically class action lawsuits, matters with dozens or hundreds of plaintiffs, years of financial records, and corporate misconduct spanning multiple jurisdictions. This is a single plaintiff in a case centered on interpersonal conduct, alleged harassment, and a coordinated media campaign. 1,000 exhibits is not a sign of meticulous preparation. It is, legal practitioners will tell you, a sign of something else. The defense made this point clearly in their filing. They argued that it is difficult to imagine that even half of what was submitted would ever be placed before a jury. Many of the exhibits, they noted, consist of lengthy collections of text messages, pages and pages of communication with no specification of which individual messages are actually intended to be introduced at trial. Others appear to include attachments whose status is unclear. The filing noted a technical problem as well. The way the exhibits were organized made it impossible to tell where one exhibit ended and another began. But the detail that stands out most sharply is this one. Among the roughly 1,000 exhibits submitted, at least 100 of them were social media posts. And here is the critical problem with that. Those social media posts were apparently never provided during discovery. Discovery is the formal legal process through which both sides exchange evidence before trial. The entire purpose of discovery is to ensure that neither side is blindsided at trial by something they have never seen before. When a party submits exhibits at the pretrial stage that were not produced during discovery, that is not an oversight. It is a problem that the opposing side has every right to flag before a judge. The defense flagged it. They raised the issue directly with Lively's counsel in a formal meet and confer session. Lively's team acknowledged they were investigating possible technical errors, but they declined to reduce the scope of what they had submitted. Their position, as stated in the letter, was that the volume was appropriate. The defense disagreed, and the disagreement landed in front of the judge. If the exhibit question raised eyebrows, the witness list compounded the concern. Lively's team identified more than 40 trial witnesses, 40 individuals whom her legal team intends to call to testify during a trial that is scheduled to last 2 to 3 weeks. Here is what that actually means in practice. Each witness who takes the stand must be examined by the party who called them. The opposing party then has the right to cross-examine that witness. If cross-examination raises new questions, the original party can conduct redirect examination. A contested witness, someone whose testimony is central to a disputed fact, could easily spend 2 hours or more on the stand by the time all of that is complete. If you do the arithmetic on 40 witnesses at even a conservative estimate of 90 minutes each, you have already consumed the better part of a month in witness testimony alone. That does not account for opening statements, closing arguments, jury deliberations, or the time spent on legal objections and procedural disputes during the trial itself. This is not a trial timeline. It is a calendar, and the defense made the point plainly in their filing. The same overreach reflected in the exhibit list was present in the witness designations. They noted that Lively's list included deposition testimony from witnesses who, by their own admission on the record, had no personal knowledge of the events in question, witnesses who testified that they could not recall relevant details, or who were asked to review documents they had never personally seen. Under the federal rules of evidence, testimony of that nature is generally inadmissible. It does not belong in a pretrial submission, and the fact that it was included anyway speaks to the broader pattern of the submission being constructed without the kind of focus that the pretrial stage demands. And then there are the jury instructions. Under normal circumstances, jury instructions are a carefully negotiated document produced jointly by both parties, refined through conference with the judge, and designed to guide jurors through the specific legal standards they must apply when evaluating the evidence. They are important. They can be consequential. A single word in a jury instruction, the difference between whether a juror must find that something was done intentionally versus knowingly, for example, can change the outcome of a case. So there is genuine reason to treat jury instructions with care. But the joint draft at issue in this case runs to approximately 85 pages. 85 pages of proposed instructions covering all 13 currently active claims in the case. For reference, complex multi-party commercial litigation often produces jury instructions in the range of 30 to 40 pages. The figure here is more than double that in a case that is supposed to be resolved in under a month of court time. The defense raised this in the same filing, noting that finalizing those instructions under the existing timeline while simultaneously managing the pretrial order, the exhibit lists, the witness designations, and motions on a range of legal issues was simply not feasible within the time they had been given. They were not asking to abandon the process. They were asking for one additional week. That request, a single 1-week extension of the pretrial submission deadline, is where the tactical dimension of this case becomes most visible. Baldoni's team, referred to in court filings as the Wayfair parties, submitted a letter to the court seeking a brief extension. They were specific. They were not asking to push back the trial date. They were not seeking to delay the proceedings in any meaningful sense. They were asking for 7 additional days to process the volume of material that had been dumped on them at the last possible moment before the deadline, and to prepare their own pretrial submissions with the level of care the court deserves. Lively's team declined to join that request. That refusal is significant for a reason that deserves careful attention. In prior instances during this litigation, extensions of this kind were granted by agreement. Both sides consented, the court accommodated the request, and things moved forward. This time, Lively's team broke from that pattern. They not only refused to consent, they filed their own letter to the court characterizing the extension request as an attempt by Baldoni's team to delay the trial. That framing does not hold up to scrutiny. The request was for a 1-week extension of a pretrial filing deadline. It explicitly preserved the trial date. Characterizing it as a delay tactic requires either a misreading of what was filed or a deliberate decision to spin the request in a way that makes the opposing party look obstructionist. Either possibility is worth noting, and the judge noticed. Before the legal back and forth could extend any further, Judge Louis Lyman issued an order granting the extension. The court also scheduled a video conference for April 2nd at 5 o'clock in the evening, open to the public through an audio-only dial-in line. The one-week extension was granted. The pretrial deadlines were adjusted accordingly. Lively's effort to block that accommodation did not succeed. There is a larger structural problem sitting beneath all of this, and it connects directly to why the pretrial submissions look the way they do. Since January, the court has been sitting on what are called dispositive motions, specifically a motion for summary judgment and a motion for judgment on the pleadings. These are legal mechanisms by which a party argues that certain claims in the case should be resolved without a trial, either because the law does not support them or because the undisputed facts clearly favor one side. When a judge rules on those motions, the ruling does something essential. It narrows the case. Claims that cannot survive legal scrutiny get dismissed. Claims that remain are the ones that go to trial. Everything that follows from that ruling, the exhibit list, the witness list, the jury instructions, the scope of the trial itself, gets shaped by what the judge decides to keep and what the judge decides to throw out. Judge Lyman has not issued that ruling. Months have passed since those motions were argued, and the order has not come down. In that vacuum, Lively's team finds itself in a genuinely awkward position. They do not know which of their 13 claims will survive to trial. So in one sense, submitting a broad exhibit list that covers every possible theory of the case is a defensible response to an uncertain situation. You do not want to build a narrow pretrial submission around claims that the judge then allows to proceed, only to find yourself scrambling to add material you left out. The problem is that this logic, taken too far, produces exactly what the court is looking at right now: a submission so broad, so undifferentiated, and so poorly organized that it functions less as a pretrial roadmap and more as a document dump. And the defense is not wrong when they say that preparing a proper response to that kind of submission under a compressed timeline is genuinely burdensome. Judge Lyman bears some responsibility for this situation. The delay in issuing the dispositive ruling has created the uncertainty that both sides are now navigating. That is a fair observation. But the fact that the court has delayed the ruling does not excuse submitting 1,000 exhibits with inadequate organization and little apparent effort to distinguish between what is actually admissible and what is not. The question that hangs over all of this is the one that is hardest to answer with certainty, but impossible to ignore entirely. What does this behavior tell us about the strength of Blake Lively's position? There are two ways to read it. The first is the most charitable. Lively's team is being thorough, perhaps excessively so, because the case is genuinely complex and the stakes are high. They want every possible piece of evidence preserved and on the record. The discovery of those social media posts that were not previously produced may be a technical error rather than a strategic choice. The breadth of the witness list may reflect genuine uncertainty about which witnesses will prove most important once the judge narrows the claims. On this reading, the submission is sloppy, but not sinister. The second reading is less forgiving. A legal team that submits 1,000 exhibits, including material never provided during discovery in the days before a pretrial deadline, then refuses to agree to a one-week extension for the other side to process it, and then characterizes that extension request as a delay tactic, is a legal team that is either poorly coordinated or deliberately using the volume of material as a tool. Volume can serve a strategic purpose in litigation. It can overwhelm opposing counsel, force them to spend resources sorting through material rather than preparing substantive arguments, and create the appearance of a case so vast and documented that the other side must surely be in the wrong. Whether that is what is happening here is something only the people inside that legal team know for certain. But the pattern of behavior, the breadth of the submission, the refusal to narrow it when challenged, the decision to frame the extension request as obstructionist is consistent with a team that is under pressure and responding to that pressure in ways that may not serve the long-term interests of the case. The hearing scheduled for April 2nd carries real significance for the trajectory of this case. It is a video conference, open to the public through an audio dial-in, which means observers will have a rare window into the court's thinking. The judge will have the opportunity to address the pretrial submission directly, to push back on the scope of what Lively's team has submitted, and to offer the kind of guidance that might have prevented this situation from developing in the first place. More importantly, many legal observers believe that the April 2nd hearing may be preceded by or accompanied by the long-awaited ruling on the dispositive motions. It would be procedurally unusual for the court to hold a pretrial conference without first narrowing the case through those rulings. There is little reason to discuss a verdict sheet, for example, when neither side knows how many claims will be put to the jury. The more logical sequence is for the judge to issue the dispositive ruling first, reducing the scope of the case to whatever claims survive, and then hold the conference to manage the pretrial process in light of that narrowed scope. If that is the sequence, it will answer a great many questions. It will tell us which of Lively's 13 claims the court finds legally sufficient to proceed. It will allow both sides to focus their pretrial submissions accordingly. And it will almost certainly render the existing exhibit list, all 1,000 proposed entries, dramatically less relevant, because many of the claims those exhibits were designed to support will no longer be part of the case. That is a significant development, regardless of how it falls. If the court dismisses a substantial portion of Lively's claims, the pretrial process resets in a meaningful way, and the submission that has generated so much friction will need to be reconceived almost entirely. If the court allows most of the claims to proceed, the defense will have to reckon with a broadly framed case, and the pretrial skirmishing will continue. Step back from the specific procedural details for a moment, and a pattern emerges that is worth naming directly. This is a case in which the plaintiff Blake Lively filed serious allegations against a director and his production company, allegations that generated enormous public attention and shaped media coverage in ways that clearly favor her side of the story in the weeks following the filing. The allegations themselves have not been tested in court. They remain allegations. And yet the public conversation around this case has, for much of its duration, proceeded as if the outcome were already known. What the court documents show is a more uncertain picture. The dispositive motions filed by the defense have been pending for months, which means the court has not yet concluded that the defense's legal arguments lack merit. If those arguments were clearly frivolous, courts typically dispose of them quickly. The prolonged deliberation suggests the court is giving the arguments serious consideration. That does not mean the defense will prevail on those motions. It means the case is genuinely contested in ways that the public narrative has not fully reflected. The pretrial submissions reinforce that reading. A legal team that is confident in its case, that believes the evidence speaks clearly in its client's favor, and that is proceeding toward trial from a position of strength does not typically need to submit 1,000 exhibits for a 2-week trial. Confidence tends to produce clarity and focus. What Lively's team has submitted looks less like confidence than like an effort to cover every possible angle in a case where the outcome is genuinely uncertain. That observation is not a verdict. It is not a prediction. It is an observation about what the documents reveal when you read them carefully and without the assumption that either side's public narrative is accurate. One more dimension of this case deserves attention because it is the part that most coverage treats as background noise when it is actually central to everything. The pretrial process, the motions, the submissions, the exhibit lists, the witness designations, the jury instructions is not procedural housekeeping. It is where cases are actually shaped and, frequently, where they are won or lost before a single juror is seated. A well-crafted pretrial order signals to a judge and to opposing counsel that the party submitting it knows their case, knows which evidence is essential, and knows what they need to prove and why. A poorly crafted one that is overlong, disorganized, and filled with material that will never survive an evidentiary challenge signals the opposite. It tells the court that this party either does not know their case as well as they should at this stage of proceedings, or that they are using the pretrial process to accomplish something other than moving efficiently toward trial. The defense caught this. They raised it in formal filings. They brought it to the judge's attention in a measured but pointed way, noting that the scope of what they had been handed was not just inconvenient but contrary to the purpose of the pretrial process itself. And the judge, without extended briefing or argument, granted the relief they requested. That is a small thing on its face. A 1-week extension. But what it reflects is that the court heard the complaint, found it credible, and acted on it. That is not nothing. Judges do not grant extensions because they feel sorry for busy lawyers. They grant them when the reason for the request is legitimate and the equities favor it. In this case, the equities were not ambiguous. Here is where this leaves us. A trial that was supposed to be a focused, relatively contained proceeding over the course of 2 to 3 weeks is, at this pretrial stage, looking like anything but. One side has submitted an exhibit list with roughly 1,000 entries, a witness list exceeding 40 names, and a jury instruction draft approaching 90 pages for a case involving a single plaintiff. The judge has not yet issued rulings that would clarify which claims will actually be tried. A conference is scheduled that may or may not be preceded by those rulings. And a public narrative that has largely favored the plaintiff is running well ahead of what the court record actually supports. None of that means Blake Lively does not have a legitimate case. She may. The allegations she has leveled are serious, and if proven, they would describe conduct that any reasonable standard of professional and personal accountability would condemn. But the legal standard is different from the moral one, and the court record at this stage of the proceeding raises genuine questions about whether this case is as strong, as focused, and as well-prepared as the public has been led to believe. What happens at the April 2nd hearing and what the court does with the dispositive motions will tell us a great deal more. It will begin to separate the legal reality of this case from the media reality, and those two things have been drifting apart for some time now. There is something worth reflecting on here that extends beyond this particular case. In high-profile litigation involving public figures, the story told in the press and the story told in the filings are often dramatically different. The filings are harder to read, less emotionally satisfying, and far less likely to go viral. But they are where the actual case lives. They are where strategy is revealed, where preparation is evaluated, and where judges form their impressions of the parties before them. If you want to understand a case like this one, that is where you have to go. What do you think this pretrial filing says about where Blake Lively's legal team actually stands? The court documents are public record, and they're speaking quite clearly for anyone willing to read them closely.